Hi everyone. There we go. It is my pleasure to speak at the Faulkner Law Review's Symposium on the role of the executive in the Anglo-American legal tradition. No doubt this topic was chosen well in advance of the 2016 election. Had Hillary Clinton been chosen, as most people assumed she would, I would likely be talking about principles of administrative law or deference to executive branch agencies. But this did not happen. Instead, over the past 8 months, and yes, it has been only 8 months, President Trump has rocked our legal order, setting up frequent and bitter clashes with Congress, the states, the judiciary, and the people. At the outset, I should note that I oppose much of President Trump's agenda as a matter of policy. I reject many of his views in immigration, economics, national security, civil rights, shall we say decorum, and other areas. Before the election, I joined a prominent letter of law professors who opposed Trump's election, a decision that has not inured to my personal benefit, but one I stand by firmly to this day. Both my cards on the table, I remain in a somewhat lonely minority of law professors who find that most, not all, of President Trump's actions are supported by his constitutional and statutory authority. These are matters that I've written about at great length elsewhere. My remarks today will focus on something else, the so-called legal resistance to President Trump. What is the nature of this movement? In both the short term and long term, what will the effects be of the legal resistance on the judiciary? And will the legal resistance succeed in changing the role of the executive in our Anglo-American tradition? And these are the topics that I want to explore with you today. So going back to November 7th of 2016, by all accounts, it looked like Hillary Clinton would be the next president. She would appoint maybe Merrick Garland or perhaps someone further to the left to the Supreme Court. John Roberts or Stephen Breyer would become the median voter on the court. This would have radically changed our legal order, which for better and probably mostly worse has been teetering on Anthony Kennedy's shoulders the last 2 decades or so. But then President Trump won, and it shattered the hopes and the dreams of the left for a progressive polity, at least for maybe 4 years, or even sooner. The day after the inauguration, a number of progressive lawyers convened a meeting known as the Rise Above Conference. It was at the Mayflower Hotel in Washington, D.C. The mission was clearly stated: how to thwart the Trump administration in the courts. Again, this was the day after the inauguration, before basically anything had been done. Jamie Raskin, who was a law professor who was elected to Congress, called on the group to coordinate a new movement to, quote, plan legal resistance to the incoming Trump administration and Republican-controlled Congress. I don't know that Raskin invented the term legal resistance, but this moniker soon caught on. On January 30th, a week after President Trump took office and shortly after his travel ban took effect, the New York Times highlighted the advocacy of, quote, liberal advocacy groups who were determined to make, quote, legal resistance one of the defining attributes of the Trump era. The article noted that shortly after the inauguration, these progressive organizations put aside institutional rivalries and organized to work together on litigation. The Nation noted that the refugee ban sparked a new kind of legal resistance group into being. A few days later, CNN observed that the legal resistance to Trump's actions is also growing and already has octopus-like tentacles, with different groups seeking to unravel or block the most controversial aspects of his executive actions. In March 2017, National Public Radio reported that David Cole, the legal director of the ACLU, is the man at the heart of the legal resistance to Trump's agenda. Why am I giving you these quotes? They don't consider this term pejorative. You may think they do, but they actually embrace it and they welcome it. So I will gladly use the moniker legal resistance because they themselves have blanketed themselves with this patriotic mantle. Now, the legal resistance was not limited to groups outside government. The card-carrying members were the states, and I kind of expected this. On January 18th, 2 days before the inauguration, I wrote a piece on National Review titled, "How the States Can Help Trump Make Federalism Great Again." My general theme was that attorneys generals that had been suing Obama for years should now look to perhaps work against Trump to develop federalism where possible. I fully expected that Democratic AGs would take the playbook of Texas and Arkansas and Alabama and other states. I didn't know how quickly that would come to fruition. Shortly after the travel ban was filed, the attorneys general of Maryland, of Hawaii, of Washington filed suits. And they were able to obtain nationwide, really global injunctions barring the enforcement of President Trump's orders. There's also been similar litigation by blue states about sanctuary cities. These state AGs have adopted a playbook from Texas quite well, and now we're seeing the chickens come to roost. But this legal resistance is not limited only to outside legal groups and state governments. We actually saw within the executive branch a card-carrying member of the legal resistance. Believe it or not, members of the civil service do not always agree with the incumbent president. So on January 31st, the Washington Post blared a headline, "Resistance from Within. Federal workers push back against Trump." Yes. Lawyers within the Justice Department and other federal agencies sought to, quote, push back against the president's initiatives. Now, civil servants don't have a loyalty oath, but they're generally expected to do their job. They can do so legally, and a lot of these people are not. Perhaps the first martyr from the legal resistance within the government was Sally Yates. Remember her? Yeah, feels like a lifetime ago. Yates was a holdover from the Obama administration who was only in office because the Democrats refused to confirm Jeff Sessions in a timely fashion. Don't forget that. Had Sessions been confirmed on day one, we would have never had Sally Yates. But they didn't. Yates refused to mount a defense of President Trump's travel ban in court. She acknowledged that the Office of Legal Counsel had reviewed the policy. She said that the Civil Division could defend it in court, but she would not because she found it not, quote, wise or just. There are grounds on which the Attorney General can decline to defend a statute. Its wisdom or justness is not one of those grounds. Now, I'll give Yates the benefit of the doubt. If she felt compelled to not defend this law, she had one choice: resign. She could have stepped down if she believed the policy was wrong. But instead, she did something far worse. She stayed in office and did nothing. So while the states were challenging these policies in court, she instructed DOJ employees, do not defend this ban. Think about that for a minute. The government had no defense in court for the first couple days until President Trump fired her for what I call uncivil disobedience. But Yates was visible. Other employees, what I call the shadow cabinet, are not. And contrary to Yates's profession, the DOJ lawyers have mounted a pretty decent defense of the travel ban. Hasn't succeeded yet, but they've got a couple of dissents from judges. This position was not irrational. But the legal resistance is not just in the lawyers, the states, and the executive branch. Unfortunately, it's spilled over into the judiciary. Shortly after President Trump took office and signed the travel ban, federal judges fell over themselves, one after the other, to issue broader and broader nationwide injunctions, barring the president from enforcing his statutory and constitutional authorities. These decisions are profoundly flawed. And last night we had some discussion of the travel ban. I want to focus on another aspect, the Establishment Clause. So more than a decade ago, Justice Souter warned courts that when searching for an impermissible religious purpose, they should resist performing a, quote, judicial psychoanalysis of a drafter's heart of hearts. And yet, judges in Hawaii, Virginia, Maryland have done exactly that. they've halted President Trump's orders by trying to read his mind. The opinion is basically premised on the fact that President Trump and his acolytes have made public statements that tell us the true reason for these policies is not national security. The true reason is hatred. But as Justice Souter warned, it is not the court's job to peer into the president's psyche. And it doesn't matter if Trump is somehow different than his predecessors, or if his insults of judges breach Oval Office decorum. The judiciary should not abandon its traditional role simply because the president has abandoned his. There's a famous case that came about during the Korean War. President Truman nationalized the steel industry to prevent a labor strike that would have hindered the military supply lines. In the so-called steel seizure case, the Supreme Court ruled that Truman's actions were unconstitutional because neither the Constitution nor Congress gave the president the power to seize private property. In the most influential decision from the case by Justice Jackson, he explained that when the president acts pursuant to power delegated by Congress, in combination with his own inherent constitutional authority, the action is, quote, supported by the strongest of presumptions and the widest latitude of judicial interpretation. As a result, the judicial inquiry is at a minimum, and the action is most likely legal. Courts should look to Jackson when discussing the legality of Trump's executive actions. Trump, like his 5 immediate predecessors, relied on a 1952 statute that gave him the power to deny entry to a class of aliens he deemed detrimental. This express delegation of authority, combined with his inherent powers under Article 2 over foreign affairs, should dial down the court's level of scrutiny. Alas, the court didn't even bother to cite this 1952 statute in the first round of opinions. Instead, they evinced broad skepticism in an area where courts traditionally have deferred to the executive. More to the point, the courts have simply assumed that the president's orders should be treated no differently than a mundane, monument to the Ten Commandments posted about 5 blocks that way, right? Too soon? The Supreme Court has interpreted the Establishment Clause to prevent the government from acting with an impermissible sectarian purpose that favors religion over non-religion. However, the Supreme Court has never used the Establishment Clause to invalidate an immigration law affecting foreign policy. To the contrary, our immigration laws routinely classify those who come from other countries on the basis of faith. Indeed, for the last half-century, Congress has given immigration priority to, quote, ministers. Yes, the statute says ministers, favoring the religious over the non-religious. And the implementing regulations of the statute express a distinct preference for Catholic, quote, nuns, monks, and religious brothers and sisters. That's in the statute. It says nuns and monks. A 1989 immigration law gave special treatment to Jews or evangelical Christians who were fleeing the Soviet Union. Yes, the statute says Jews or evangelical Christians. Atheists need not apply. Asylum law forces immigration judges to discern the contours of a faith and decide whether an alien complies with those tenets. All of these provisions run afoul of the Supreme Court's Establishment Clause jurisprudence. Not even close. Yet there's never been the slightest suggestion that these actions are unconstitutional. Yet, a judge in the Ninth Circuit argued that we should just apply these Establishment Clause cases in the normal context. That's not right. In the absence of any guidance from the Supreme Court, lower courts should hesitate before extending the Establishment Clause to the foreign policy context. But even assuming the Establishment Clause applies with full force to foreign policy, these decisions enjoin the orders based on impermissible and unjustifiable skepticism. In 2005, the Supreme Court held that Mercury County, Kentucky, violated the Establishment Clause by posting a copy of the Ten Commandments in this courthouse. Justice Souter's opinion explained that the displays were motivated by an impermissible religious intent, even though the county defended the policy by citing the Decalogue's role in our legal system. Quote, Although a legislature's stated reason will generally get deference, he said, the secular purpose required has to be genuine, not a sham, and not merely secondary to the religious objective. Now, had any other president issued Trump's exact same order, word for word, this sham analysis would be the beginning and the end of the inquiry. Half of the nations on this list of banned countries are state sponsors of terrorism. The others, they don't adequately assist the United States with counterterrorism efforts. Is it a sham to conclude that undocumented immigrants from these nations should be subject to heightened vetting? And while procedures are being reviewed, the issuance of new visas should be paused? The answer would certainly be no, in light of Justice Jackson's tempered wisdom about the separation of powers, and by giving proper effect to the executive branch's long-standing authority over foreign affairs. Alas, we are not living in normal times. The federal courts have halted the orders by finding in the heart of Donald J. Trump an impermissible animus. The specifics of the second order, and indeed now the third order, are irrelevant. What matters is what Trump said throughout his career about Muslims. In December 2015, then candidate Trump called for a, quote, total and complete shutdown on Muslim immigration entering the United States. Over the next few months, Trump shifted his position from the Muslim ban and moved to what he called extreme vetting of people from certain territories. Or did he actually change his position? Cue PolitiFact, right? During a July 2016 interview on 60 Minutes, Trump told Leslie Stahl that she can still call it whatever you want, but we'll call it territories, okay? Was that an actual repudiation or a wink in the nod to the alt-right? However, a week later, on Meet the Press, Trump seemed to clearly repudiate the old policy to Chuck Todd. I'm talking territory instead of Muslim. Did he really mean it? Was this fake news? Alas, the burden of reconciling these statements has shifted from fact checkers to the federal courts. A federal judge in Virginia found that Trump's CBS interview connected his initial call for a Muslim ban with his January 2017 immigration order. The proverbial missing link, right? But she inexplicably did not cite his repudiation and Meet the Press. Another judge acknowledged Trump's reversal on NBC, but dismissed its relevance because Rudy Giuliani talked about it in Fox News. I hope you see how insane this is. You have federal judges arguing about the meaning of an order based on what different people say in cable news. We've moved beyond the looking glass. We are down the rabbit hole, right? It's come to this. Called upon to decide whether the president's immigration policy was, in fact, designed to exclude Muslims, rather than to screen out dangerous people from war-torn nations, the federal courts have confronted a frighteningly bizarre question. Is Leslie Stahl or Chuck Todd a tougher interviewer? This is the nature of our judiciary today. And from the inside, they think they're saving the world. From the outside, I can just laugh. This entire line of analysis is mistaken. The courts have tarred Trump with the brush of bigotry, a phrase that Chief Justice Roberts used in the gay marriage case some years ago, by citing statements that were not connected with the executive order issue, but rather go to his general state of mind toward Muslims. Such introspection is precisely what Souter advised against in McCreary County versus ACLU. Again, quote, a judicial psychoanalysis of the drafter's heart of hearts. Generally in court, evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with a character trait. You know that from evidence, right? This is black letter. 2 L's know this. Absent evidence the policy at question was in fact actually motivated by this anti-Muslim animus, and no, Rudy Giuliani's comments do not count. The court's opinion amounts to a psychological profile of a, frankly, perplexing man who is taking contradictory policies on every issue of public discourse. Look what he says. He will often contradict himself in the same sentence. Trying to make sense of it is not something the court should even attempt to do. I've given up a long time ago. So although these judges reject the notion that Trump's past conduct must, quote, forever taint any effort by him to address the security concerns of the nation, it is hard to see how this analysis would ever permit the executive branch to impose any immigration policy that impacts predominantly Muslim nations. Imagine if Trump were to announce that he wants to conduct drone strikes in Syria to root out radical Islamic terrorists. Could a court halt those actions, finding that they were motivated by the same anti-Muslim animus the president expressed on the campaign trail? Or could a court halt an executive action, say defunding Planned Parenthood, because it bears animus towards women, citing the president's famous rapport with Billy Bush on Access Hollywood? Nothing Trump can do would ever eliminate that taint. This brings us to recent litigation by the New York Attorney General. Eric Schneiderman has argued that President Trump can't revoke DACA, the Deferred Action Policy, because he's racist. That's actually the argument. The complaint states that the president has demonstrated a willingness to disparage Mexicans in a misguided attempt to secure support from his constituency, even when such impulses are impermissible motives for directing government policy. The filing cites a litany of Mr. Trump's offensive comments: his warning about Mexican rapists, his disparagement of Univision anchor Jorge Ramos, his reference in a presidential debate to bad hombres, his attacks on Judge Gonzalo Curiel, as well as pardon of Joe Arpaio, the former sheriff of Maricopa County, Arizona. The states argued that these remarks, as a matter of law, established that Mr. Trump has a racist heart, and the administration's actions are therefore irrational. Although Mr. Trump's comments should give pause to his voters, and they did for me, courts cannot properly consider them in evaluating this policy. The legal resistance is free to scroll endlessly through @RealDonaldTrump, and what they find there may carry political weight. But courts need a limiting principle, namely, the judiciary should consider statements from Mr. Trump only if they're directly relevant to the case at hand. Federal judges have grossly erred by citing Mr. Trump's campaign statements to justify halting his executive orders. In those cases, at least, there was some connection between the final policy and what Mr. Trump had proposed during the campaign. By contrast, the comments cited by the New York Attorney General have nothing to do with DACA. The judiciary should rebuff this attempt to deprive the president of his lawful authority. I doubt they will. But let's go back to the travel ban, and I want to discuss a theme that the Solicitor General's office has developed, and that is the presumption of regularity. This is a phrase the government has littered its brief with. And I'll read you a quote from the government's brief. Under the Constitution's structure and its separation of powers, courts evaluating a presidential policy directive should not second-guess the president's stated purpose by looking beyond the policy's text and operation. This is President Holloway's remarks last night. The presumption of regularity that attaches to all federal officials' actions applies with the utmost force to the president himself. During oral arguments in the Fourth Circuit, Acting Solicitor General Jeffrey Wall, who's my Fed Courts professor, repeated this phrase, presumption of regularity, 4 times. Now, the judge in the Fourth Circuit were not so keen on that. Judge Floyd asked, quote, if there's anything other than willful blindness that will prevent us from getting behind those statements. Jeff Wall replied, quote, respect for the head of a coordinate branch and a presumption that officials act legally, which is to say the presumption of regularity. Chief Judge Gregory interjected and asked about whether that presumption prevents courts from assessing the constitutionality of actions. This is the Marbury question, right? Whenever they cite Marbury, you know where they're going. By the way, if you want to uphold a law, cite McCulloch. If you want to strike it down, cite Marbury. Simple rules for living, right? Whenever a judge cites McCulloch, they're about to uphold a federal law. It's a constitution of propounding, right? When they're going to strike it down, it's Marbury. So get your Marshall straight. Yeah, it's true. Trust me on this one. Go read Robert's opinion, one way or the other. He cites either Marshall in McCulloch or Marshall in Marbury. Anybody wants to. I think you're both wrong. Chief Judge Gregory, during the arguments, topic for next year maybe. Chief Judge Gregory, during the arguments, interjected and asked about whether the presumption prevents courts from assessing the constitutionality of actions. And so Solicitor General Wall replies, it does not. But that the only thing plaintiffs have to reach out to is what's in the president's head. He admits there are different ways to read those political statements, but insists that respect for a coordinate branch and a presumption of regularity requires reading them in a way that is not most hostile to the president, but would render the actions lawful. It's remarkable that the Solicitor General of the United States has to tell a court, do not be hostile to the president. That's precisely what they've done. Judge Wynn, also in the Fourth Circuit, said that far from regularity with respect to President Trump, we are in, quote, uncharted territories. And Solicitor General Wall replied, respectfully, the district court's opinion was itself unprecedented. As a means to discount statements made by Trump prior to inauguration, the acting Solicitor General put a lot of weight on the oath of office. The government contends that the oath transformed Trump, a constitutional baptism, if you will. And the earlier campaign statements in the campaign trail are off limits. The acting SG explained that since various political statements were made in the campaign trail, we've had some significant constitutional events since then. Right? The president was elected, he took an oath, he formed a government. He consulted with his administration. Judge Motz interjected and said, but that doesn't give him the right to violate the Establishment Clause. Wall replied, these events should color the way we reach back and look at previous statements before he was an elected official, before he faced the demands of government, before he consulted with an administration and took an oath that allowed him to occupy the nation's highest office. Wall explained, out of respect and the presumption of regularity, we do not give the president the least charitable interpretation of what he said. We give it the most reasonable interpretation in order to render the executive order lawfully. Wall closes with what I think is his most important point. He said, the order should not drift in and out of constitutionality based on what we think is in the head of the president that issued it. This drove home the theme that Trump should not be treated any differently than other presidents. Indeed, the ACLU had to concede during their arguments that had President Clinton issued the same order, it would be constitutional. The legality of the order should not fluctuate based on the president that issued it. Yet, we may be in the midst of what I refer to as a revolt of the judiciary. Judges across the country are signaling that they are not going to treat Trump as they would any other president. The sorts of analysis we've seen are frankly insane under long-standing law. But maybe I'm naive, right? Maybe I'm wrong to simply assume that usual precedent applies to Trump. Ben Wittes and Quincy Juracek, writing at Lawfare Blog, wrote that maybe courts think Trump is unable to follow his oath of office. He's a pathological liar, he's a sociopath, whatever adjective you want to use. So, therefore, the usual rules do not apply. So I want to read a passage from their article, which I think is quite good. To put the matter bluntly, why are so many judges being so aggressive here? The legal disputes are both interesting and important, but this meta-legal question strikes us at least as far more important and far-reaching. And we think the answer lies in judicial suspicion of Trump's oath. The question goes to the manner in which we can expect the judiciary to interact with President Trump on this and other issues throughout his presidency. It goes, not to put too fine a point on it, to the question of whether the judiciary means to actually treat Trump as a real president, or conversely as some kind of accident, like a Forrest Gump, right? Is Greenville, Alabama is that a real place? Not that. Oh, sweet home, right? To treat Trump as a kind of accident, a person who's somehow ended up in office but is not quite the president of the United States in the sense that we would have recognized it. And I think that goes a long way to explaining how a lot of people see Trump. He's not legitimately elected. We could talk about Russia for the next 8 years, it won't matter. He's not really the president, which is the basis of the legal resistance. But I respectfully submit that if President Trump is removed before his time's up, it's through the impeachment process or the 25th Amendment. If he keeps firing cabinet secretaries, the 25th Amendment gets a little bit easier because there are few people to persuade. I'm serious about that. You might be down to just him and Jeff Sessions at that point. But he got fired too, who knows. But the point is these sorts of arguments will bleed. They're not going to be constrained to Trump. And I want to read a statement that the Solicitor General made during arguments in the Court of Appeals. He said, "The order before this court has been subject of a heated and passionate political debate. But the precedent set by this case for this court's role in reviewing the president's power at the borders will long transcend this debate, and this order, and this constitutional moment. In cases like this one, which is such intense feelings on both sides, we respectfully submit it is all the more important to apply the usual rules of interpretation and injunctive relief." The usual rules. But by and large, progressive lawyers have not sought that. In fact, Dawn Johnson, a professor at the University of Indiana, Bloomington, has argued the exact opposite. She's argued that the usual screens of deference, that's her phrase, the usual screens of deference for the executive should be modified for President Trump. But she's no fool. She's very smart. She knows President Elizabeth Warren will be in office in 4 years. Elizabeth Warren needs all the deference she can get. So Johnson wrote, "In order not to jeopardize executive power more generally, and for other presidents, Democratic presidents, in contexts where deference will remain appropriate, courts should take care not to downplay or sanitize facts peculiar to Trump that especially shift burdens and diminish deference to." In other words, make this Trump law, limit it to Trump, and then in 4 years go back to normal. Presidents can do whatever they want. They can decline to enforce immigration laws. They can decline to enforce marijuana laws. Whatever they want. Make up Title IX rules. Whoever. They can make up whatever they want. But for the next 4 years, we need to follow it. The Fourth Circuit didn't listen to the Solicitor General. They listened to the legal resistance. And Chief Judge Gregory, who assigned to himself a 70-page majority opinion, explained that under this order, President Trump has made foreign aliens feel like outsiders. He said the travel ban is not bona fide. He cited cable news appearances from Rudolph Giuliani and Stephen Miller over official statements from the Department of Homeland Security and State. Think about that. You're citing people who are not in government on cable news over the actual people in government who are telling you this is legitimate. They concluded that the policy was in fact animated at animus. In fact, this is a quote, "It drips with racial intolerance." That sort of language wasn't used in Brown or actual cases involving civil rights. This sort of language is frankly stunning in a case that is facially neutral. Regrettably, the decision was also pocked by a lot of errors. The court totally ignored the dissents from 3 judges, and they covered them with what I call papier-mâché bulwarks, basically saying, yeah, this is not perfect, but let's keep this on the books as long as Trump is president, and we can distinguish it later. At bottom, the legal resistance to the travel ban amounts to a not too transparent exercise of motivated reasoning. Construe precedents as broadly or narrowly as needed, and draw all inferences and the like least charitable to the president. Motivated reasoning is not new to the judiciary. We're all mortal here. But is particularly brazen in the travel ban cases. Okay? Now, it's true that President Trump disrupts all political norms. The court should not respond in kind by disrupting judicial norms. Trump's presidency will come to an end sooner or later, but the precedent set here will linger far longer. Now, I want to close by speaking a little more broadly about the effect of the legal resistance. One of the common tropes of this movement is we must resist normalizing Trump as president. I don't know what that means. He was elected, he got the votes, he's president. He's certainly not normal in the sense of his predecessor, but he is the president. It's fine, though, for these private groups to make these arguments, but courts have followed that lead. When judges treat the president as anything other than normal, it sends a signal to the public that the chief executive is not as legitimate as his predecessors. For example, when Justice Ginsburg suddenly skips President Trump's joint address to Congress, and remember her criticisms of President Trump. This looks very strange after years of giving President Obama warm and effusive hugs at the State of the Union, right? That matters. It sends a signal. You know, such behavior is par for the course on cable news, but it should not infect the judiciary. Trump was elected through the same constitutional process by which judges receive their lifetime commissions, and he should be treated as such. A fellow traveler of this traditional judicial posture is someone presented last year, Judge Bill Pryor of the 11th Circuit. He wrote a commentary to Virginia Law Review that I'd like to read from. He couldn't be here today, he had a meeting in D.C., but I will bring his presence here. So Judge Pryor wrote, "For those who are concerned about judicial independence, history suggests that judges have an opportunity to do something besides complaining. It is not too much for us to look in the mirror and ask whether some criticisms are fair. As Justice Harlan explained in his famous dissent in Plessy, the courts best discharge their duty by executing the will of the lawmaking power, constitutionally expressed, leaving the results of legislation to be dealt with by the people, the representatives. Perhaps even today, we, that is judges, sometimes fail in that limited and critical duty. Alexander Hamilton explained in the Federalist number 78, Judge started with the Federalist here, see? That judges exercise, quote, neither force nor will, but merely
judgment.
Thank you. Yes, merely judgment. A little karaoke for the law review. Hamilton's point was that we must depend on the persuasiveness of our writings and written opinions to command the respect of our fellow citizens. In that way, Judge Pryor wrote, we have the foremost responsibility of safeguarding our independence. And roll tide. He didn't actually write that. I'm sure Judge Pryor would be opining at this point. Or as Justice Gorsuch really framed it, or recently framed it, judges should wear robes and not capes. They're not here to save us. Lord help us if we have to defend on judges to save us. I think we're toast at that point. It is true, again, that Trump disrupts all norms. The courts should not respond in kind by disrupting those norms, the judicial norms. Trump's presidency will come to an end sooner or later, but the precedent set here by the legal resistance and by the court will linger far, far longer. Thank you all so much, and I welcome your questions.
Any questions?
Yes. Yeah, you call out, that's fine.
Who's over here?
Just, if the United States were to be attacked by North Korea, would you still push your legal resistance agenda toward the military not to follow orders and commands of the commander-in-chief of the United States of America?
That is such a good question.
Or protects its citizens or its allies?
That's a very good question. You couldn't hear it in the back. The question was, if we're attacked by North Korea, should members of the military engage in legal resistance? That's generally what's called insubordination. And our editor-in-chief, what's the penalty in the military for refusing to follow an order? You can tell us.
If it's during wartime, it's execution. If it's during peacetime, then it's 20 years of Leavenworth.
How many people have ever actually been executed? Has anyone ever been executed for that? I know Washington pardoned a couple people back in the day.
Not since World War II.
Yeah, it's been a while. So, but this is not an idle inquiry. There are legitimate discussions among constitutional law professors that if President Trump issues the call to fire a nuclear missile, can the chain of command refuse, right? And there's some, fantasy that General Mattis was like, no, we will not fire that missile. Let me tell you something. If that order comes down, the missiles will be fired. Is that a fair assumption? This guy worked in the Air Force for 20 years. Something he is knowledge.
I would expect we would faithfully execute those orders.
Yeah. So let me put it this way. I think launching a nuke in North Korea would be absolutely insane. But we elected the guy. We elected him. We gave him the nuke codes. He has a football. And Lord help us if he uses it, but that's how it works. In fact, I am more concerned about what an insurrection or military would look like than actually leveling Pyongyang. Right? I have far greater concern for how our republic would survive basically a coup. Look at Latin America, right? Look at how every 5 years there's another dictator thrown off. I don't want that for a polity. We've survived dumb bombing missions before. We've bombed Southeast Asia. It was awful. But the consequences of this internal resistance within the government, I think, has far more staggering effects for our rule of law. Yeah, I don't want to nuke North Korea. Please don't quote me. I do not want to nuke them. No nukes. But I think the other side will be worse. Adam?
Josh, great talk. Really enjoyed it, as always. Question about your somewhat offhand allusion to the religion clauses and potential implications. So one possible reading why these federal statutes would privilege Jews and Catholic and evangelical Christians in immigration laws is religion clauses just don't apply in this context. Another possible interpretation is whether it satisfies the sort of neutrality interpretation that has been put on the religion clauses for the last half century or so, insofar as there is a non-pretextual reason for these distinctions, and the effects or burdens on particular religious groups are incidental or secondary. So that leads me to wonder, is one of the possible implications of this this rather aggressive use of the judicial power that we might witness the unraveling of the neutrality interpretations of the religious clauses, and that might be what's behind these judicial analyses.
Fascinating question. So, the Establishment Clause is one of my least favorite clauses of the Constitution because it's a mess. I wish all we had was a neutrality principle. There are these other cases too about disfavoring religion, right? So if all we had was a neutrality case, then I think you're game. But we have precedents in the book to say if government evinces a disfavor of religion, that's unconstitutional. And that means basically a preference for religion or atheism, for example. And under that regime, having a regulation that gives immigration preferences to monks and sisters would not survive scrutiny in a minute with our domestic law. But maybe you're right. Maybe we can bring back neutrality and make that the cornerstone of the First Amendment, in which case this order is patently constitutional. It makes no reference to religion whatsoever. The first order, there were three orders, I'll describe them briefly. The first order had a reference to protecting religious minorities, not Christians, not Muslims, but religious minorities. That's gone. The second order had a reference to honor killings. That was a script. They should not have left that in there. Honor killings are associated with Muslim nations. That's gone. The third order, the most recent proclamation, is completely facially neutral. There's no reference to religion whatsoever. And if you want to take a neutrality standard, this one is passed with flying colors. But thank you for your question, Adam.
As far as the military faithfully following the orders of the commander-in-chief, what about unlawful command influence or, disobeying an unlawful order? I'm Air Force, so I question things.
Oh, I thank you for that. I don't know. You want to answer this? We got an expert in the
I'm
house.
sure you're more qualified than I am to answer that question.
But you give it a stab. What do they teach you in the boot camp of following unlawful orders in your various trainings?
To put it simply, I would say we don't make that decision. It would be someone above us who would.
How high up?
Well, they don't define that, of course.
Yeah.
But in a tactical field sense, if you're a soldier on the field and your immediate commander says, I don't know, kill that innocent child, that's an obvious illegal order and you shouldn't follow it. But I understand the context there where we're talking more of ignoring presidential orders as the commander-in-chief. That's going to be some sort of decision that's somewhere higher up. They're going to make that decision, and the rest of us will likely follow that lawful order.
Yeah, and let me follow up with an answer. There's no argument. I think this Professor Holloway's comment last night, because the legal resistance needs to go to the intent of the order, that basically concedes it's spatially neutral, right? Because we need to go through this entire rigmarole of checking CNN and Fox News and whatever else, it concedes that on its face is legal. Because if the order was void on its face, these would be very easy cases, right? 5-page opinions, who else could write it? But because they're valid on their face, you have to go behind it. Now your question is the order unlawful because of the president's animus or intent, right? I think that's where you're going with this. this is what Sally Yates said. Oh, I think the travel bans may be legal, but I think it's unjust. That's not a decision for government officers to make. If they are giving an order they disagree with, they can either resign or resign. And if they're in the warfare, I think that's they got left for that. I think, is that right? Yeah. Thank you for the question. Yes, Professor.
I have a question about another aspect of the legal resistance, and if you don't have an opinion on it, that's fine. But do you have an opinion on the merits of the Emoluments Clause lawsuit against you?
Have you Googled me?
No.
Well, thank you for asking.
All right.
So I have filed 2 amicus. I swear this wasn't a plant. I swear it wasn't. We talked about this. I have filed 2 amicus briefs in the Emoluments Clause litigation. A third will be filed on this Friday. The Constitution actually has 3 emoluments clauses. About 1. There's one that prevents Congress from, members of Congress from taking a position for which they've raised the salary of. So if I'm Hillary Clinton and I increase the salary of the Secretary of State and Senator, I can't become Secretary of State. She did anyway. I'll put that later. There is an emoluments clause for the President that says that the President's emoluments cannot be increased. The way I read that is Congress has the President's emoluments. Other people can't hire him for a second job. The one at issue in this litigation is the Foreign Emoluments Clause, which provides that no person holding profit or trust under the United States shall receive any presents, titles, or emoluments from any foreign states of any kind, whatever. Paraphrasing, I my notes handy. Most people have never heard of the Foreign Emoluments Clause before 2016. This guy has. And I'm close colleagues with a law professor in Ireland, Seth Barrett-Tillman, who has been researching this for a decade. And I long ago came to the conclusion that the language in this provision, office under the United States, applies to appointed officials and not elected officials. It's used in several spots. So this provision, as we argue in our brief, only affects appointed officials, not elected officials. And I had a week-long stint at the Vol conspiracy last week if you want to read about it. So our position is the President's not bound by the Foreign Emoluments Clause. But let me explain, actually, it's a good segue to legal resistance. I swear this wasn't planned. There's a couple documents that are relevant in this inquiry. Okay? In 1792, the Senate asked Alexander Hamilton, as the Secretary of the Treasury, to put forward a list of all the emoluments of people who hold civil office under the United States. Now, the language there about emoluments and civil office under the United States is very similar to what's in the Foreign Emoluments Clause. Hamilton spent 9 months preparing this list, and he put forward a 90-page manuscript, which was very intricate, very detailed, listing all the salaries of appointed officials, but not elected officials. So we look at this as one piece of evidence, one of many pieces, that suggests that this phrase, office under the United States, refers to appointed and not elected officials. Now here's where the resistance comes in. Professor Tillman had put these documents online almost a decade ago. We knew all about these documents. There's another document, which is a condensed version of this report, which does list the President. The problem is it was drafted after Hamilton died. It was probably drafted maybe in the 1820s, probably in the 1830s. It has a signature on it, but it's not Hamilton's signature. It was made by a scrivener. Now, Seth knew this years ago, and I knew this years ago. So we put in our amicus brief for the Southern District of New York a claim, and we said, there's this other document, but the court should not give it any weight because it wasn't signed by Hamilton. Fine. Enter the legal resistance bloggers. There's a blog, I don't need to say its name because it's not worth reading, but attacks me on a fairly regular basis. And one of their experts made a discovery at the National Archives of this other document signed by Hamilton. Now, we had put it online years ago. It's available. There's nothing to discover. And he said, aha, Hamilton signed this other document. Okay, fine. I couldn't care less about a blog post. But then a group of 5 legal historians, including some from Georgetown and Stanford, prominent guys, put this claim in their brief that we were misleading the court by failing to look at this other document. And we were simply perplexed because Hamilton had signed it. So we actually put a pleading to the court with the affidavits of 5 experts, actual historians, saying that Hamilton did not sign this document. New York Times wrote an article about us, and they called Professor Tillman a lonely professor. But the Times said, Tillman's right. You want to know something? This morning, the historians, to their credit, sent a letter to the court and withdrew their claim. to their credit, the Take Care bloggers have not apologized in any way, shape, or form. Professor Lawrence Tribe and others have even acknowledged their gross error. But that's the point of legal resistance. Truth is irrelevant. Truth is irrelevant. If it stops Trump, it doesn't matter. Just ignore it and move on, hope no one notices. Now the New York Times noticed, Bloomberg noticed, all conspiracy. So there's plenty of attention. People can see these people for who they are. But with the legal resistance, truth is secondary. What matters is stopping Trump and moving on. But I do give the credit to the professors. They withdrew their claim. The footnote actually about 2 hours ago, so this is fairly breaking news. But I swear this question was not a plant. Next.
Got a question over here.
You had mentioned the admissibility of President Trump's statements in interviews being used in court proceedings. My question is kind of twofold here. One is, what about tweets and how do they apply? And then number two is, are those tweets or social media posts from the president subject to the government laws relating to destruction of government documents?
So I've taken to calling President Trump our commander in tweet. The world would be much better if his battery died and never turned back on. But fortunately, I don't think General Kelly has enough clout to take his Android away from him. But let me answer your question like this. As a general matter, I think statements of these sorts are not admissible. But I do think there are certain exceptions. Campaign statements for the inauguration, totally off limits. Statements made after the inauguration that show that the actual stated purpose for a, let me put it this way, if you actually have some policy that's on its face is illegal, and you have some ancillary statements that seem to bolster that, I think looking to the president's statements can be permissible. But I think what we have here is a statement's facially neutral. And under the Supreme Court's precedent, Kleindienst versus Mandel, all you have is facial review. You don't go into tweets. Now, the second part of your question, are the president's tweets subject to the Presidential Records Management Act? I think the answer is yes. The government has basically said the president speaks through Twitter. Those are official statements of the president, and they should have all the force. What's an executive order versus proclamation versus tweet? I don't think it matters. When the president says something, that's the order and that has the weight. But these are statements I don't think should be used in court under normal circumstances. There may be some circumstances where they're appropriate, but the travel ban with foreign policy, I think this is a mere rational basis review. These sorts of statements should be utterly irrelevant. But thank you for the question.
Do we have any other questions? All right, well, a round of applause for
Thank you so much.
Next on the agenda is a lunch, which I believe we served at noon. For those who are registered for CLE credit, we'd like you